Good afternoon. Welcome and thank you for signing on to this webinar. I'm Dave Sherwyn. I am a professor at the Nolan School of Hotel Administration at Cornell University, and I'm here with my guest, Ilene Berman, who is a partner at the Continuum Legal Group in Atlanta. And we are going to spend most of our time today talking about the new law with religious accommodations. So, Ilene, thanks for being here.
You're welcome. I'm excited to be here. Thank you.
And I think we might even have some fun. So
I think so.
I'm looking forward to it.
We always do.
Yes. So just a little background. Ilene and I met at orientation when we both entered the ILR school at Cornell a really long time ago, and I promised her I wouldn't say how many years.
Thank you.
You're welcome. And so, and after ILR as undergrads, we both went to law school and then started practicing labor and employment law. And when we started practicing labor law, or employment law better, the law about religious accommodations was set. And this June, it was radically changed, this past June. So I'm going to kick off by explaining where we were, and hopefully, and then asking you to tell us where, how you practiced and how you used the law, and then we'll talk about the new law.
Sounds good.
So here's the background. Title VII of the Civil Rights Act was passed in 1964, and Title VII protects race, color, national origin, sex, and religion. Put religion last because that's what we're talking about. And within the concept of religion, if you look at the other protected classes, the theory is it's all about equality. There's men and women, no difference. Black, white, whatever, no difference. And when it comes to religious discrimination, that's the same concept. But when it comes to when your religion requires certain behaviors or appearance or so on, that was the question. And initially, there was the argument that it would be unlawful to require employers to accommodate religion because it would violate the Establishment Clause of the Constitution. And so in the late 60s, what we had was some cases going out there saying that for those who are reading Title VII to require accommodations, it can't require accommodations. Right. And so kind of lived with that for a little bit. But then that changed. Court cases came in, and it was during the time, and it was around the time of Vietnam.
Yep. And
in the Vietnam, people trying to avoid the draft, conscientious objectors. And the standard for the objectors was whether they had a sincerely held belief that going across the world and fighting a war was wrong. And so we had a lot of law of that going that way. And then it kind of moved back to Title VII with religion. And in 72, Congress amended Title VII to require accommodations. And in the legislative history, as well as some court cases that were going on, they took that Vietnam era standard of what is religion. So it didn't have to be a top five. You just you needed a sincerely held belief. The question came out, they gave us a term, and they gave us a kind of saying that you had to provide reasonable accommodations that were not an undue hardship. That was the standard, but what did it mean? And that led us in the late 70s was a case, Hardison v. TWA. And this is the case that defined what accommodations were for all of us. In school we read it, and then when we got out of school we practiced it.
Correct.
And the story of Hardison is fairly simple. The guy worked at TWA, and it was a unionized environment, and because he had seniority in his, they called it building 2, he didn't have to work weekends. But Building 2 also worked nights. Working nights wasn't desirable, so he moved to the other building. But now he was the low person on the seniority list. And because of that, he would now have to work about 10 weekends a year, 10 Saturdays. And Hardison was Jehovah's Witness. And
recently converted,
Jehovah's Witness. And his, the Jehovah's Witness Sabbath is Friday night to Saturday.
Right.
So he said, I can't work Saturday. And So he came up with his proposed accommodations. One, I'll work 4 days a week and let somebody else work overtime. That would require not time and a half, but half, because instead of paying Hardison, you're paying this person time and a half, and
Right.
you've saved on Hardison's time. His other options were just be one person short, have a supervisor fill in,
Yep.
and went to the employer and or reject the seniority system.
Right.
And union said no, that's out.
Yeah.
So that wasn't going to happen. And TWA said no, we can't live without the person. And managers manage; they don't do the job.
Right.
So the only option is overtime. And they did the math, and it would cost TWA per year approximately $150.
In 1977.
When a round trip ticket from New York to LA was $178. I looked it up.
Excellent.
So less than the cost of one round trip ticket to allow this person to practice his religion and remain employed.
Yep.
And case went up to the Supreme Court.
Wait, and TWA said, we're not going to do it. It's an undue hardship.
Right. TWA said no, not going to do it. And so now it goes to the Supreme Court and lay it all out. And the Supreme Court agrees with TWA and very clearly, right at the end of this opinion, says these magic words that anything that has more than a de minimis effect on the business is an undue hardship. And when I teach class, and I used to teach this, now now I don't teach it as much, but now I've got a new opinion. But when I would teach this, and the students look at me like, "What's de minimis?" And I'd say, "You and your friend are working a restaurant together, and you've got to punch in at 10 o'clock. And on the way there, one of you sees a friend. So one person punches in at 9:59, and the other person punches in at 10:01. And when you both punch out at 5 and you get your paycheck, they're exactly the same, because that 2 minutes was de minimis. But if the other person had punched in at like 10:05, there'd be a difference.
Sure.
And so that's de minimis is
Basically nothing.
basically nothing.
Yep.
So now I go to you. So you've been practicing. You've got employers, obviously, in heavily, in labor-intensive industries, and you've had folks coming up to you forever saying, "What do I do when I need to accommodate religion?" But I do want to, before I ask you to answer that, I do want to throw in something else. In '92, we got the Americans with Disabilities Act. And the Americans with Disabilities Act, it didn't go through that kind of messy stuff like religious accommodations did. It says right out there that there's 40+ million people in this country with disabilities, and this is going to open the door. The line was it's the Emancipation Act for people with disabilities. And it's in there that, hey, employers, you're going to have to fund this, because we're going to take a bunch of people who were really prevented from having careers, and we're going to allow them to use their minds and use their bodies and be able to be employed.
Right.
But it might cost you some money. So you had reasonable accommodation that's not an undue hardship for religion, which meant this, and for disability, which meant that.
Right.
So
I mean, it was a dilemma because it's the exact same phrase, reasonable accommodation, unless it causes an undue hardship to the employer. But the standards were vastly different. And the religious accommodation cases that I've seen over the years prior to June of 2023 really involved two main areas: appearances, where employees requested some deviation from a dress code or a grooming standard in order to practice their religious beliefs, or they required, similar to Hardison, they needed a schedule change. And they fell into those type of cases, and clients would call and ask, I have a religious accommodation request. This employee wants to, is an evangelical Christian, does not work on Sunday. We are a 24/7 operation. What should I do? And we talk through it. There is a duty to accommodate, so let's see if we can meet that duty. The duty would be What kind of cost does it have on the company to try to accommodate giving this employee Sundays off? And like you said, if it was just a slight increase in some cost, operational cost, administrative cost, impact on employees, whether it's from a morale perspective or how they perceived management in favoring one employee over another, if it was just a slightly elevated burden, we would advise that you do not have to accommodate. You could deny the request. And it was a pretty easy advice to give because it was a very low threshold.
And when we think about that and we think about religion versus disability, and what you just said, which right on, is that I listen and I look at what it would be for the employer to do. And if you have to do pretty much anything, you don't have to do it.
Yeah.
But when we looked at disability, the first question wasn't so much what will it cost. The first question is this person
qualified?
Is this person truly disabled?
Yeah. Well, that's true. Right. Do they have a disability that is protected under the ADA?
Right.
And that's a whole separate analysis. If you're trying to compare that with what did we say when somebody came to us and said, I am a practicing evangelical Christian and I need this accommodation, did we question at first whether they held a sincerely held belief? We really didn't, because we didn't have to, because that was the burden. The next question you have to ask was a light one. So we gave employees the benefit of the doubt. That isn't the case with disability claims or disability accommodation requests, at least in my experience. And I think you've studied this. Is that right?
Yeah, I have numbers.
Okay, there you go.
That's what I do, because
yeah.
you
I live in the real world.
Right, you have a real job, and I read stuff, and because
and compile data.
Right, and pretend that it matters.
Yeah, it
but
does.
Okay, I'd like to think so.
At some point down the road, it matters.
Right, and so what we looked at there's a professor at Ohio State who's made a career out of studying the ADA.
Okay.
And I've always been skeptical of the conclusion, because the fact is ADA plaintiffs lose more than anyone else. The conclusion seemed to be that's because none of us like people with disabilities, and I never bought that.
Yeah.
What I looked at and said, well, wait a second, it's hard to be protected under the ADA. You need to have a physical or mental impairment that substantially limits one or more major life activities.
Yep.
And
It's a mouthful.
Right, it's a mouthful, and you got to prove it.
Yeah, the employee has to prove it.
Right. And then you have to prove, while you have that disability, you're still able to do the job.
Correct.
With or without a reasonable accommodation. So looking at that prior work from others, and I compiled a bunch and found that 65% of ADA plaintiffs were found to either be not disabled, or if they were disabled, they couldn't do the essential functions of the job. So we don't have to get into accommodation.
That's staggering, 65%.
Right. And so that's where the number came. That's why ADA plaintiffs lose, because they don't even get in the game.
Right. They're not protected. That's the decision. They don't have the protections of the ADA.
Exactly. But
compare that to religious accommodation requests?
So I looked at religious accommodation cases for about an 8-10 year period, from 08 to either 16 or 18, forget right now, and I had about 250 cases.
Wow.
And the question was, again, these are reported cases that were summary judgment motions, so it's not the entire universe, but it's the published summary judgment motions. But that's the same comparison with ADA.
True.
So here's my quiz. How many cases did the court find that the person was not qualified or not protected because they didn't have a sincerely held belief in their religion?
So I know the answer because I read your law review article.
Okay.
But it was absolutely shocking to me. And it was 0.
Right.
Not a single case found in favor of the employee. Well, every case found in favor of the employer. Is this right? Wait, let me make sure I get this.
No, every case found in favor of the employee on prong one.
Sincerely held religious belief.
Right. You're protected, you have religion, you have a sincerely held belief. Now let's move to the de minimis standard. Oh, wait, we don't have to do anything. Thank you, good night.
Yeah, employer wins.
Right, employer wins.
So employee wins stage one, employer wins stage two, where it's completely different with the ADA.
Right. And so, and our favorite case, and we've talked about it, it's the Costco case where the employee was a devout follower of everyone's favorite religion, the Church of Body Modification.
Unbelievable.
1,000 members worldwide, and the tenant is have lots of piercings.
Correct.
And she wanted to wear I think it was an eyebrow.
Or lip.
Lip and eyebrow.
Okay.
Yeah. And
oh, yeah, it was
an
eyebrow. Yeah.
And Costco said no, that was going to, destroy the whole morale and, and the employee, the employment relationship.
And the image of the company.
Right. The image of the company. Because if I go to Costco and if I see an eyebrow here, I'm out.
Yeah. I am not buying those gigantic toilet paper rolls because it's offensive. But remember the year this was too, okay? Because these are, what was Costco, 2000?
It was. I think it was more recent than that. But you're right. It was at a point where 5-star hotels didn't have people with tattoos.
Yeah. I mean, we've evolved a lot on that. But yes, but the whole point is that this did they go to the Supreme Court? No, it
was First Circuit.
First Circuit, yeah. Is that the image of the company and the alleged impact it would have on customers and others was enough for Costco to prevail and not allow her to be accommodated by letting her wear her piercing on her eyebrow.
Right.
That was it.
But so it's back to exactly what we were saying, which was that they kind of gave you a pass on whether or not you have a sincerely held belief,
right.
Unlike the ADA, where we scrutinize whether you're truly disabled.
I mean, you litigate that hard as an employer, just because it's more narrow, obviously, to qualify. Even with the ADA amendments, it still can be a challenge.
And the thing is, you litigated it hard because, I read this as I was doing that law review article, that the average, or I don't know if it was a mean or a median, accommodation of the ADA is like $500.
Yeah.
But on the other hand, there is the potential for real money.
Sure.
And if you're Cornell or Apple or Google, you can never say I can't afford it.
Never.
So it's just a matter of whether it's reasonable, and that's sort of a cost-benefit analysis of
It used to be.
Yeah, to society versus the cost and so on, is right. To see if the if it's reasonable, because it's never going to be an undue hardship for a company with
a giant company.
Yeah, that has more money than most countries.
Correct.
So that's just not going to happen.
Right.
So, but now we move back to religion. So religion was, we're going to accept whatever you say your sincerely held belief is. But we don't have to do anything, so we're not going to accommodate you. So in that time, you had some accommodation cases that you had to deal with.
Yeah, and you, as an employer, best business practice is to try to accommodate. I will tell you that. The advice was not, the default wasn't always no. It's let's engage in the interactive process. Let's see what impact it would have on generally business operations, employee morale, like I said, how management is perceived, and if there was any resistance at any of those, the employer would say, I don't want to do it. Do I have to do it? And I said, the burden is so low that I think the risk is small.
So for you, it sounds like you were advising it was more of an HR issue than a legal issue.
It really was.
And
that's what we do as employment lawyers. We don't just look at the hard and fast rules of the law, but also how does it work within the operations of your business, the culture of your business, the morale of the employees, the impact on the workplace, of course.
And that could go both ways.
For sure.
Because you could look at it and say, this is a loved employee, and if we don't accommodate this employee, there's going to be an uprising.
Or we're going to lose that employee, they're going to go to another employer.
Or we're going to
they're a valued employee, they've been here for a long time. It's usually a new hire, I will tell you.
Okay.
or it's somebody who potentially has converted and now is practicing and needs the accommodation. That's where we see it. It's not a long-term employee you've had for forever and out of the blue, unless there's a conversion, that you would have these type of religious accommodation requests.
So then the morale could go the other way. Because you got
Correct.
this new employee, and this new employee,
Right.
I'm sticking with Hardison and saying, the Sabbath starts on Friday, and I lived in Chicago where it gets dark at 4:20 in December.
winter, yeah.
And so if somebody lives an hour and a half away, they're out of there at 2:30.
Right. And the
And-
shift ends at 5:30.
Right.
And it's Friday.
And it's Friday. Exactly.
So people start to resent that employee for getting, if we granted that, if we change their shift, if we restructure the job, we transfer them, whatever, there starts to have an impact on others. And you don't share this information with other employees. You don't talk about the accommodation because that's a personnel decision that's between the employee and the employer. So there's a lot of speculation and potential rumor and gossip. I mean, it could really unravel into a situation when that might not. It's a difficult one from an HR perspective, but.
And so, right, so if it's that new employee that doesn't.
That no one knows.
That no one knows and doesn't care about that much.
Right.
Then to take that kind of cost and create that kind of noise made no sense.
And it wasn't legally required.
And you didn't have to do it.
Right.
So we kind of moved along with this. I would say it was same words, different meanings.
Yeah.
But we did it, and we educated ourselves, and we educated our students and our clients, and life went on. And I think folks kind of got the memo. So it's not like you were inundated with these religious accommodation cases, but then COVID showed up.
Right.
And now what we had were people who had a sincerely held belief against vaccines.
Right.
And because we don't question sincerely held beliefs, we didn't really ask them if they had 12 other vaccines.
Right.
We just said, okay.
Well, when certain employers in multiple industries decided that the vaccine was the safest, based on the medical evidence, way to protect their workforce from the pandemic, right? And they decided to impose a mandatory vaccine requirement. But some of my clients set up a system that allowed for exemptions, either under the ADA or under Title VII for religious accommodations. And they did, with legal oversight, question whether the objection to the vaccine was truly based on a religious practice, that it conflicted with a religious belief or observance. And the way that they analyzed it is they would ask questions about the basis for the religious accommodation request. And when the basis was socially oriented or political or personal, and never mentioned religion, if you will, they would be denied eligibility for the accommodation. And that was the first time that I had seen clients really decide to scrutinize that part of the test. Okay?
But I saw that too. But also our friend Celeste, maybe she's watching. Celeste called me up just to read something to me one day.
Yeah.
And she's like, this is an employment situation where it's there's no educational requirements and so on. And she had gotten this note from someone. I have a sincerely held religious belief. I mean, it was like tracking statutory language. So, the employees got the memo really quickly.
Churches were handing out forms the language to put on your employer's accommodation request form. And we would see them over and over again. They all went to the same church, and this is what they were being advised, and this is what they felt that they needed to do in order to be exempt from having to take the vaccine. And in that case, because it was coming from a religious entity, employers tend not to question it. But when it sounds like it's a political stand, then you feel more comfortable, the employer felt more comfortable saying, this doesn't qualify under Title VII. But again, this was all new.
Right. It was all new, but then, again, people got the memo and they started
They
doing
did
it.
it, and so then you went to the next stage, which is, would the accommodation request create an undue hardship under Hardison, more than a de minimis cost to the employer? And let me tell you, they were, unless the employee, in situations that I advised, could work 100% remote and didn't have to appear in person on site around other employees, they would get their accommodation request granted. If they had to come on site and work and be around others, even if they could socially distance or wear masks and be tested weekly, they determined that the vaccine was the safest way to protect the employee and their workforce, and they would deny the request based on undue hardship.
And then if you go with employees who are customer facing,
Easy.
that was easy. We're not going to have our guests, customers, whomever comes into our place of business be concerned.
No.
So
everyone's vaccinated. You come on in. This is the medical guidance that we were receiving at the time. Remember, this
Right.
is a temporal, thank goodness, pandemic, right? And so that's what we stuck to, that this was a temporary mandate, but we are going to enforce it in a way that we think is the safest way to protect our workforce, which is what every employer's paramount concern was at that time.
So questions come in as we're doing this,
Yeah.
and the first question that we have is something we're going to cover later, so I don't bring it up.
Okay.
But the other question is, it's from John, are there higher employer costs, real or perceived, associated with disability versus religion? Are they basically the same? Well,
Wow.
the answer is, and we're going to get, it's a kind of a good segue to where we're going.
Okay.
Because the answer was, a year ago, I would say, there are really no costs associated with religion because you don't have to spend any money
No.
because you don't do anything, and there can be legit, real money costs for disability, especially if you're an employer which has some means.
100%. I think there is. I mean, will change now, but yes, there were significant costs with disability accommodations.
Right.
But creating an undue hardship, did those costs create undue hardship? It's relative,
Well,
right?
the undue hardship was right. It was exactly relative. Like again, in class, I give the example of this person wants to be a chef and they want to work at they're the greatest chef in the world and she wants to work at Cornell Dining. Go figure. And Cornell can't say I can't afford it. But then I mention our favorite restaurant, Souvlaki House, and I say Chris can't afford it.
Yeah.
So he could say
relative.
no.
Yeah.
But Cornell could never say no.
No.
But with religion, they could both say no.
That's right.
But now, so you advised your clients about vaccines.
Yeah.
You advise your clients about piercings and
Grooming standards and schedule changes and shift swapping and all of that.
And for the most part, you said, we're not going to mess with whether you're religious or not,
That's
because
right.
there's 50 years of courts not messing with whether you're religious or
Yep.
not and finding the church of body modification for real. So we're not going to bother with that.
Yeah.
But you don't have to do anything.
Right.
And then Groff showed up.
Right.
So and this is one of those things where Supreme Court, for whatever reason, labor and employment cases come out at the end.
Yeah.
Like, did you ever notice that?
In June.
Yeah, it's always in June. And this year we had the Harvard UNC affirmative action case
In June.
and then we had the 303 creative case. The wedding design, the wedding
Website wedding designer.
who's not really a website wedding designer.
No, but she may be.
She may be. So we had that, and that got a lot of press.
Correct.
And within the same day came Groff. And
Only the employment lawyers and academia.
right, only
We're like, what?
right, and I was watching cable news, and they were going crazy on 303 Creative and Harvard and UNC. And then the commentator said, oh, yeah, and there's another case that just means that employers can't just demand that their employees give up their religion anymore, and that's a good thing for everybody. And then the person just went on. I went, whoa, wait, it's not so simple.
Yeah.
So, Ilene, tell me about Groff.
So Groff is a case that involved a United States postal worker in Pennsylvania. He was a rural postal worker in a small post office, and he worked Monday through Friday. He's an evangelical Christian. He does not work on Sundays, his Sabbath, and that was fine. And then the Postal Service started to contract with Amazon, and they started delivering on Sundays and holidays, not every week, but throughout the year. And he was able to work around that until the Postal Service entered into a new contract, and every week there was a Sunday shift. And he stated his objection to the Postal Service and said, I need an accommodation. I need to be off on Sundays. And the Postal Service was operating under the Hardison de minimis, more than a de minimis cost rule, and said, we can't accommodate you because it would require overtime for others. It would require management having to restructure their schedules, etc. And so he started to not show up on his Sunday shift and was progressively disciplined. He ultimately quit. He said, I know I'm going to get fired. I'm done. Hired lawyers, sued the United States Postal Service, and said the de minimis standard is too low. That's not what Title VII requires. It says undue hardship. And we want the court to clarify. He would want to overrule Hardison, but let's clarify that undue hardship means the plain language of those two words are understood. He lost at the district court in the Third Circuit. They both courts said we're bound by Supreme Court precedent, and he appealed to the Supreme Court. And under this Supreme Court,
well, before you keep going, because I don't know if you caught this one, but about 2 or 3 years before, there was, I don't remember the facts exactly, but there was a similar case with Walgreens.
Yeah.
And they applied for cert to the Supreme Court, and Alito, in denying cert, said, this has to be addressed. This isn't the right case.
Wow.
So the plaintiff's lawyers in Groff, they knew that they had a court that was welcoming to them.
Sure.
And so, Alito was saying, give me the case. And so the Groff plaintiffs, or the plaintiff's lawyers, found their case.
Found their case and found the majority opinion writer in Alito. And it's interesting to me that it's a 9-0 decision. It's a unanimous decision. Alito took it and wrote the opinion. Justice Sotomayor and Justice Jackson wrote a concurring opinion. Not much meat around that, but they all agreed that Hardison was not, didn't the de minimis standard that almost 50 years of court precedent had relied on, that's not what Hardison meant, essentially.
So,
that it shouldn't be reduced to a single sentence in a 30-page decision. That does talk about what undue hardship means in lay terms, but the courts just held on to that de minimis language. And so they said, we're going to clarify that. We're not going to overrule it, because they said it wasn't necessary to overrule Hardison. So
right, and so when you look at that, basically they told us that everything that we can't really read.
No, and neither can courts for the last 50 years.
Right, and
hundreds of courts.
Right, and every employment law class in the country,
in every law school, and every undergrad.
Right, we can't read, and when it said, and therefore we hold that anything more than a de minimis effect is an undue hardship, they didn't mean that.
They didn't mean it.
Right. So what they said wasn't what they meant.
But the entire bench, all 9 justices, agreed that was the right result. So that's fascinating to me too, because there's something called stare decisis, right? It's precedent that we've all relied on for years. That's part of the law and how lawyers operate, and how professionals that rely on lawyers operate, HR professionals, business owners, etc. And that is just thrown out the window. It really was, because the standard is completely different now.
And you go in and, I mean, you think about it, how many times do you read a case where they say, this has been the law for 50 years, if the legislature got the memo, and if they want to change it, it can? And
they've done it employment arena, right? But
We had the Civil Rights Act of 1991.
correct.
So
Equal Pay Act. I mean, there's a lot of laws that touch employment that have been modified by Congress after the Supreme Court has issued a ruling. It has happened multiple times. This time, the Supreme Court didn't do that. They just said, this is what undue hardship means. Essentially, ADA standard, but they wouldn't even be that clear.
Right. They didn't even say that because, and going back when we're saying, what they didn't do, in the Civil Rights Act of 1991, the preamble to that says, we're here to overturn Watson, we're here to overturn Ward's Cove, and we're here to modify Price Waterhouse.
Right.
Well, Hardison at that time was 15 years old.
Yeah. Didn't say anything about that.
It was in the neighborhood. You could have gotten them if that was a problem.
Yeah.
But Congress didn't see it as a problem.
No.
And then the ADA came right out, and Congress still didn't see, while they were in that neighborhood, to say, hey, look, we got to line these things up.
Right, exactly right.
And it's interesting, and I agree with you, whenever you see 9-0 on something that is not just like perfunctory, like nothing, it makes you what's up with that?
Absolutely.
But I think that when you look at the 3 liberal justices, if it's an employee-friendly ruling,
of course they're going to rule in that way.
and then as we talked about that Catherine Franke op-ed, which says the Supreme Court stacks rights,
Yeah.
and they have put religion at the highest level of rights. So that's how you got the conservatives.
Yes.
So they didn't see it as pro-employee, they saw it as pro-religion.
Correct. I agree.
And so now we have,
Let's say what the standard is.
what's the standard? Eileen?
Okay. Because that's important. So the standard is that the more than de minimis cost is out the window. So forget that. It has to, what undue hardship means is it a substantial increase in cost in the context of the employer's business? Okay? That's the language. I've memorized it. Now ask me what it means.
Eileen, what does it mean?
Beats me. It's substantial increase in cost in the context of the business. So have my notes, okay? Because there's some things that they want, the court has given some practical impact analysis or assessment. The court says, we must look at what is the nature of the business, what is the size of the business, and what are the operating costs. Does the accommodation request have a practical impact on considering those things, the nature of the business, size of the business, and operating costs, such that there is a substantial increase in costs? So, if you have to pay, well, let me add one other thing. The court did specifically say, and relied on EEOC guidance, on what is not an undue hardship, okay? So keep this in the back of your mind so you know. Increase in temporary costs for a period of time, which I'm not quite sure how any of this is temporary, because somebody needs an accommodation for a religious request, they're going to need it, indefinitely, right? As long as they work there, unless they change their religion.
Well, or unless
practices.
You're looking at a religion that doesn't have a weekly Sabbath, but it's like it's going to cost us a lot, but it's every 6 months.
It's four times a year.
Yeah, whatever.
Okay,
So maybe
fair.
that's I don't know, but I'm trying here.
But an increase in a temporary cost is not undue hardship. Voluntary shift swapping. You tell the employee, go talk to the other people on the shift, see if they'll switch with you and they'll work on the weekends. The problem and that's not an undue hardship. You can require the employee to do that. When I see these cases, they generally are the new hires that come on board who ask for the accommodation. They don't know anybody on that shift. No one's going to shift swap with somebody they don't know, they don't have a relationship with. So that's not even a practical, to me, option. But even if an employer said, I can do that, the court says that's not an undue hardship. Or the employer says, I can't do that because the employee doesn't know anybody. That's not an undue hardship. You got to do more.
Well, and what if you also look and say, hey, wait a second, I've got my new employee working with my veteran, and then on the other shift, I have my new employee working with my veteran, and now I'm going to have 2 new employees, and I don't want to do that.
Right.
So your client calls you up and says, this is the gig.
Yeah.
If I accommodate this person, I've got a total of like 12 days of experience on this shift. Is that an undue hardship?
I would say no, not under Groff. Okay. It's not. Now, if it happens for 3 more employees, that 3 more employees come forward, or I don't know the magic number, but if it becomes more stacking or collective or compounded, that there are multiple requests to a point where it becomes excessive on the burdens that are placed on the operations of the business, including costs, overtime, inexperience, people aren't skilled enough to be on this shift, at some point, it's going to become excessive. That's how the court at Groff said undue hardship means excessive or an unjustifiable level of cost.
And they also said the 4 worst words that any lawyer can tell their client, case-by-case basis.
It depends.
Yeah, or case-by-case, worse, case-by-case basis.
Every case has to be looked at individualized.
So we have no idea. So you can tell your client that, well, they'll judge the details, and while you're doing it, you'll be paying my hourly rate.
Yeah.
As their
yeah, each case, you have to call us and we have to assess.
Right, and then we're going to make our assessment based on, right now, nothing.
Nothing.
Well, in 10 years, we'll have, well, we won't be doing this. But but in 10 years, there will be case law.
Hopefully, yeah.
But, so that we'll say when
we can study it and understand what do these words mean, similar to how we've looked at ADA cases and undue hardship under that standard.
Right. So we'll have some idea what it means, but for now we don't. Here's the questions that we got, and he asked 2 questions together. So I'm going to say, he says, how might the Groff decision affect the balance between religious accommodations and other employee rights like gender equality and LGBTQ rights? And do you anticipate cases further clarifying the substantial costs for religious accommodation? We absolutely expect
it will be litigated. Yes, it will take time, but it will for sure. We'll get some clarification, and what that looks like. Those are hard decisions for judges to make, and it will be based on the particular facts of each case. But yes, it will take time.
Right.
And the first part of the question?
Well, and the first part is, talking about
other rights.
The other rights. And the thing is, right now, we don't have accommodations for LGBTQ. We don't have accommodations for gender. I mean, that's not part of the statute. The Title VII is thought of as sort of a colorblind, gender-blind world. And then religion kind of came in with, well, you have to accommodate, but not that much.
Right.
And then ADA is a completely different animal.
Right.
And so that's all about accommodation.
Right.
But there is no accommodation for the other protected classes. So, national origin, color, race, and sex, and also age.
Right.
So
no.
So the answer is, it's...
You don't have... There's preferential treatment for religious beliefs under Title VII. There's preferential treatment for disabilities under the ADA. That's it. The rest of the employment anti-discrimination laws under the federal laws they don't require any type of interactive process or accommodation requirements. It's just
right. It's just
go
the way
to Congress.
it is.
Right.
Yeah.
I mean, it could change on with transgender accommodations and with bathroom usage and locker room usage and things like that. But as of now, there's no requirement.
Right. There was thinking back to the early sex cases, and the term in the statute is sex. There were, it's like the traditionally male environment that only had a men's bathroom.
Yeah.
There was like, you got to build a female bathroom because that's. But
yeah,
it wasn't seen. It wasn't seen as an accommodation as much as reducing the just obvious barriers to the workplace.
Exactly.
And it was a one and done thing.
Right.
Now
that was equal opportunity analysis versus accommodating so that you are able to continue to work in this environment.
And then when we talk about, you talked about your business and morale and so on, and this is kind of fits with the question. He was talking about religious accommodations vis-a-vis gender equality and LGBTQ, but I'm going to get it out of the protected class world and just talk about other things that really matter to people.
Right.
So I don't celebrate the Sabbath, but my child's after-school sports games are at 3:30 on Friday.
Right.
And I want to go to that game. Or my child care provider is religious and leaves at 3 o'clock on Friday, so I need to be home for my child.
And as the employer says, I have to let the Orthodox Jewish employee leave at 3 o'clock to accommodate his religious beliefs. So you need to stay till 5. I have no obligation to accommodate your child care situation or your child care's owner's religious beliefs. I have to deny your request to leave early. And that creates, like we said, it really could impact. That could be a very valued employee. That employee may leave the workplace. There might be resentment towards the employee that is accommodated and gets to leave early. There's a lot of practical consequences with accommodating at a higher standard now that I don't think were taken into consideration by the Supreme Court, and we'll see how employers navigate through those.
Yeah.
It's not easy.
It's not easy, and I would, when you look at that, there's a line in Groff that where Alito basically says employee morale because they want accommodations for other things is not a substantial cost.
Not at all.
Right. So you can't say, hey, look, it's just not fair.
Right. Or everyone's really angry and no one's happy coming to work because we're doing these things to accommodate under the law. Sorry.
And so the person, and then we go back to the 6 to 67 or whatever with the establishment clause.
Yeah.
Because the person says, hey, look, I'm an atheist or I'm agnostic, but I have a sincerely held belief that I should be a good parent and go to this game.
Yeah.
But that's not a
Sorry.
not a sincerely held belief under this concept, because that's not protected by Title VII.
I agree. So what do you do now?
Yeah. What are you doing? And just to throw in one more thing, like we brought in our analysis that said they didn't overturn Hardison, and so now it's applied retroactively.
Okay, that's important.
And I was on a panel this summer with a Ninth Circuit judge, and we were I asked her and I said, well, what do you think? It's like, are you going to apply this retroactively to employers who made a decision under the Hardison standard, which was only around for like 48 years, so it's kind of new. But are you going to hold that against them and apply the new standard? And she looked at me and said, they didn't overturn Hardison. That's outside my pay grade.
Yeah.
I'm a circuit court judge. So the Supreme Court told me that this is the new standard. So you must have cases, especially with some of the vaccination cases, where you advised under Hardison,
right?
And now the case is filed, and then it's like bank error in their favor. All of a sudden, the law changed.
It's unbelievable. I actually have a case that closed. The charging party sued for religious accommodation, failure to accommodate his religious beliefs because of the vaccine mandate. The case was dismissed by the EEOC. He received his right to sue letter. 90 days passed, and his rights under Title VII have expired. Okay?
And you're in Georgia with no state law.
Correct. No state law. It's all black and white. Groff comes around, changes the standard. I get a letter from the EEOC 4 months after the expiration of the 90 days and maybe whatever, like 6 months after they issued the right to sue. They're reopening the case.
And they can create their own statute of limitations because they can reopen.
And it says that the right to sue, 90 days, is not affected by that, but the commission can bring a suit against the employer. The employee is not part of, could recover from that suit, but he can't be part of the suit because he's as an individual because his 90-day rights have expired. But the issue is they now want the employer to go back this employee was fired in December of 2021 when we made the decision to deny the request for the exemption to the vaccine mandate, and now prove that it would be a substantial hardship or undue hardship to the employer to have granted that request. Well, let me tell you, everyone's gone. Like, there's almost nobody around.
Meaning decision makers.
Decision makers, the whole vaccine mandate process is closed. All of those records are in archives. I mean, and now we have to take everybody back in time and litigate that under a different standard. And of course, the employer will have to argue that, yes, at that time, the safety of our employees, anything but the mandate of the vaccine would have created a substantial increase to the cost of our business because people could have died.
Right.
I mean, I don't know. We haven't even articulated it yet. But Groff has that retroactive effect. So decisions you made a year ago denying a request for a religious accommodation based on the de minimis standard, you might want to reconsider under the new standard, because you may have to if somebody files a charge, but even if not, maybe you should relook at those and see, can you accommodate them?
I mean, you've got a 300-day statute of limitations generally.
In most states.
In most states, not Georgia.
Not in the South.
Yes. Well, Georgia,
No, Alabama.
I mean, a couple of them have statutes.
300, yeah,
so they move it to 300.
Yeah.
If you have a state statute, it's 300. If you don't, it's 180.
Right.
But if you're within that 300 days, it's probably worth a phone call to invite that person back and cut off their back pay.
Right, absolutely. Go back and have the interactive process. It's good business practices. I always say that because of the impact it has on the workplace. There's nothing wrong with trying to have that interactive process. Trying to offer an accommodation may not be the accommodation if that employee is still there. Remember, that employee may have left because you couldn't accommodate.
Right, but you can call. Hopefully, you can find them and call them up and say, "Hey, upon further review, the law's changed."
Yeah, let's come back in. We want to talk about possibly how we can accommodate you.
Right,
for sure.
And if they, if they found other employment, then you're not really worried about back pay anymore.
Correct.
Because But
why not look back? Why not? Why not? I mean, if you can make the accommodation, obviously now you must, because it's almost at this point impossible not to meet the undue hardship standard. It's just too high. It's too unknown.
Right. It's too amorphous. You just don't know.
Yeah. And one request, if you have to pay overtime to 3 other people, and you're not a tiny employer with only 15 employees, you're probably going to have to bear that cost.
Right. Or deal with the higher cost and the more immediate cost. Like, overtime over the years, it could add up.
Yeah.
But the fact of the matter is, your bills come every month.
Yeah.
And so when there's an active lawsuit, you're going to run up money a lot quicker than you are with accommodations.
Absolutely.
So there's an ADA case from the mid to late 90s. It's Van Zandt, state of Wisconsin. It doesn't matter. But in there, it's the opinion's written by Chief Judge Posner of the Seventh Circuit.
Yeah. Mm-hmm.
And Posner says when the plaintiff wants to work at home, says no, like that is not a reasonable accommodation under the ADA. But no one's going to question Posner's intelligence, because even at that point he says one day it might be.
Right.
So he's again Nostradamus, I guess. But
Yeah,
he was looking into the future.
Right.
But now, how do you feel about when somebody says, well, I'll just work home every Friday, and the employer has said, we're back in the office, or we're back in the office Monday, Wednesday, Friday, and everybody's here Friday and I want you here?
I'd accommodate it. Yeah, I would accommodate, because I don't think that, unless the employer can articulate and convince me, who is experienced in this area, that this is a substantial increase in cost to allow that person to work from home, which I don't know how they have established that, they should grant the request. And if you deny the request, put it in writing, clearly state the basis and the reasons for doing so, and now it's more important than ever is to document everything we do on accommodations for religious requests, because we're going to start to create the data as well. And we can start to look at, what is this costing the company? Let's figure it out. What if we have to hire somebody who can, or put in place? I don't know what the accommodation would be, but if we have to bring on another individual to work on the weekends, or we need to transfer to another position, start to monetize what that looks like. Start to keep records of that. It's really important. And train your supervisors that the standards have changed, and you can't flippantly say no when someone asks to be reassigned, or some employee goes to a supervisor and says, I have a religious request, and I can't work on Sundays. And then, well, that's our shift, and that's what we told you on the employment application, and that's part of our business model, 24/7. And you have to be able to be flexible now, and start to understand that the standards have changed dramatically, and operating your business and informing your professionals, the people that supervise employees, that this is coming, and that this is here.
Well, let me ask you. We're really pushing up on time, so I'm going to do the unfair thing and ask you a.
That's a prediction. Are you asking me predictions?
No predictions. No, I'm asking you when your client calls you and says this.
Okay.
If your client called you and said, we're a barbecue place, and 95% of the food we serve are pork ribs, and I got a server that refuses to touch pork, I think we could turn around and say, you can't work here because that's all you do is serve pork.
Right.
But what if it was a steakhouse and they had pork chops, and that comes out maybe once a night because nobody orders pork chops?
Right.
Would you say that the server could take the order but then tell somebody else to bring the food out and clear the food because they won't touch a plate with the pork on it?
Yes.
And how about the person at the checkout at the supermarket who says, I won't touch bacon or something else?
It's not a substantial to grant that request, to ask another cashier to come over and help facilitate that is not going to be a substantial increase in cost in the context of that business. It's just not.
Right, but if I'm online waiting there, I think it's a substantial increase in my time. But I don't know.
But you're one customer, and it happens twice a day. I don't know. Again, that's why you have to start to track these things, right?
But then we go with customer. I mean, and
you start losing customers.
But customer preference. Remember the airline cases, Love in the Sky?
Yeah.
Our clients demand
women
barely dressed to be the flight attendants. Yeah. And the court in the 70s said, no, customer preference doesn't do it. Mm. So if it says, hey, look, your customers will wait online longer so we can accommodate this religion, we got a lot, just like we've got a ton of law of not questioning your sincerely held belief. Yeah. We've got a ton of law saying that the customer, not that they're not always right, they don't even matter. And so, that's kind of where we are.
That law doesn't help the employer by any stretch, so I wouldn't rely on that unless you can show data that people are leaving our place of business because of this accommodation.
And I don't even.
How do you? Is it worth it?
I don't even know if that matters too, because again we can go back to. The laws passed in 1964. Well, all of the clients at my law firm are, white men, and they demand white man lawyers. And, that was like, no, that's out. That's right. So it's the same analysis here. We are out of time.
Oh, we are.
So thank you for coming all the way up from Atlanta to hang out with us in the studio.
You're welcome. Thank you.
Always fun to hang.
Always. It was great.
And for everybody else, thank you for spending the hour with us. And this is a monthly series, so we're going to do it again next month. So again, thank you so much for joining on.